All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the defense.
Buckle up, guys. Today we're diving into a courtroom showdown that kicks off with a legal curveball. The defense challenges the court's authority before anything else even happens, invoking Texas Rule 12A for a special appearance. The judge doesn't blink. With sharp wit, he shuts it down. Unless this courtroom is floating in another dimension, Texas law still applies. This isn't just sass, it's a reminder that courtroom theatrics don't overrule hard law. The tone is set, and the game has officially begun.
Court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue, that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated.
Now things escalate. The prosecutor wastes no time reminding everyone that a felony in Bexar County lands squarely in this courtroom's lap. The rules are clear, and there's no backdoor exit. The judge breaks it down like a seasoned professor, explaining that the moment a felony is alleged and linked to the county, the court has jurisdiction, no loopholes. It's sharp, clean, and decisive. The law is in motion, and the defense is officially on the back foot.
Robbery that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Lesson. An indictment isn't a guilty verdict, it's a pass to go to trial. The defense might be hoping for dismissal, but the judge spells it out. Indictments just mean a grand jury saw enough to proceed, not enough to convict. It's a reminder of the difference between accusation and proof, between suspicion and justice. This is how due process protects both sides, no matter how dramatic the argument sounds.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right. Thank you. And then we have...
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling? Okay.
Yes. And
The other,
then the next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be.
The defense drops a philosophical bomb. No real injury, no real crime. But the state fires back with law and logic, citing the grand jury and legal definition of aggravated robbery. The judge adds clarity with real-world examples: a knife, a gun, a threat. These aren't abstract theories, they're lived fears. This isn't a debate class, it's a courtroom. The threshold isn't perfection, it's probability for trial. And here, that threshold's being crossed.
Valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So state, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code.
Next, things get murky. The defense tries to invoke the Seventh Amendment and accuses the court of unauthorized benefit seeking. The judge, calm, measured, surgical. She reminds him that the Seventh deals with civil trials, and this is criminal territory. No hidden agenda, no mystery payout. Just a salaried judge doing her job. This moment shows the gap between misunderstood legal buzzwords and real courtroom knowledge, and how quickly one collapses under the other.
And there's a list in the penal code of all the crimes. And aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling?
No, Your Honor.
All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars, so there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. See, I don't know. I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third party benefit in violation of the Seventh Amendment. All right. Do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right. State, do you want to respond?
Judge, regarding, I guess, the Seventh Amendment applying in case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right. So the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right. Defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right. If you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas claims it, and they're the ones that are pursuing to prosecute me,
Mm-hmm.
which is they're on the third party,
Okay.
and I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that.
And then comes the question that stops everything: how can I cross-examine the state of Texas? It's a fair ask from someone trying to understand the system. The judge answers it with precision. You don't cross-examine the state, you challenge its witnesses. She walks the defendant through the difference between criminal and civil, prosecution and complainant, system and individual. It's not just a defense lesson, it's a crash course in constitutional structure. If you found this breakdown valuable, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.
How can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen,